Hello, this is Matt on the Moon Family Sedan channel. Delisting XRP was a huge legal mistake for Coinbase and probably for any cryptocurrency exchange that ultimately ends up getting sued by the SEC that halted the trading of XRP. And look, I've been saying for over 2 years now, I certainly do have a level of sympathy for Coinbase that was thrust into this position of having to make a difficult decision and trying to protect their employees, and all of that is still true. I still feel that way, but it doesn't change the fact that from a legal perspective, it looks like, especially with the benefit of hindsight, admittedly, it does look like this notably is going to bite Coinbase on the rear side, the fact that they did this and weaken their legal arguments. And I'm going to share with you perspective from attorney Bill Morgan, member of the XRP community, on this very topic, and it's interesting here. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so there's a very short Twitter thread on your screen right here from the Cardano Times, and this ultimately was retweeted by attorney Bill Morgan, so I'm going to start the video right here. Here's what the Cardano Times wrote regarding Coinbase. And again, just to make sure that we're all on the same page here, Coinbase did receive a Wells notice, which is just a preliminary notice effectively saying, hey, we're going to sue the crap out of you. That's effectively it in a nutshell. Is there a possibility Coinbase won't actually be sued by the SEC? Technically, yes. I think the possibility for that is about zero because Gary Gensler has the votes to get this thing passed. I think that's crystal clear. So as far as I'm concerned, the Wells notice is nothing more than a formality, and Coinbase is going to be sued. I mean, I could be wrong, and maybe it doesn't happen, but I feel pretty damn strongly that that's, by a long stretch, the most probable outcome here. And Coinbase, in recent days, and I already covered it, so I'm not going to really get in depth in this video on this particular topic, but Coinbase, they pushed back and they explained to the SEC their perspective because they had an opportunity to respond. And I don't think it's going to do a damn bit of good for them, but hey, good on them for trying. And so here's what the Cardano Times wrote based on that. Breaking. Coinbase's chief legal officer, Paul Grewal, stated in a response to the SEC's Wells notice that the company is confident that the centralized exchange does not sell any securities on their platform. This includes Ethereum, Cardano, and so many others. This is a bold statement from Grewal as the SEC cracks down on unleashing their legislatively dubious regulatory authority over cryptocurrency-based companies such as Coinbase due to the agency's assertion that a majority of cryptocurrencies are indeed securities. Grewal stated that in their robust process based on SEC guidance, Coinbase rejects over 90% of the assets the exchange reviews under the premise that a majority of rejected cryptocurrencies could be classified as securities. All right, so that kind of sets the table a little bit more. And then this is where it really gets interesting, though. So attorney Bill Morgan ends up, and I think very fairly, critiquing Coinbase for their decision to get rid of XRP. And so Bill Morgan retweeted that, and that thread that I just shared with you, and then he wrote the following. And that assertion, or any assertion about its listing criteria, is undermined by its own conduct in listing, then delisting, and not relisting XRP. If Coinbase's listing criteria is so good no securities are listed, what happened with XRP? You don't reckon the SEC will use that against Coinbase? If Coinbase says it was a mistake, how does it say it has not made other mistakes about the other cryptocurrencies it lists, such as Algorand or Dash, which the SEC has alleged are securities in SEC v. Wahi or SEC v. Bittrex? If Coinbase insists XRP is not a security and it was not a mistake to list it, then it's exposed to an assertion of inconsistency as to delisting XRP. It is an inconvenient problem and one of Coinbase's own making. So let me share you a couple. I think he's obviously hitting the nail on the head. Let me share with you a couple of my thoughts on this as a non-attorney here. And then I actually do have some more from attorney Bill Morgan, which is really insightful. But, look, Coinbase's argument in theory. So I'm just going to try and think of what Coinbase could say to defend their actions. Doesn't mean I agree with it. I'm just trying my best to think, if I were them, what the hell would I argue since I made this huge, massive F up? Well, Coinbase's argument in theory could be that when XRP was delisted, they did it out of an abundance of caution, assuming the SEC might have information not available to Coinbase. Because they did an extensive investigation, right, before going after Ripple, right? Of course, the SEC could then come back and say to Coinbase, why have you not then delisted the other coins we've publicly stated are securities, such as Algorand or Dash? And in response to that, Coinbase might say, well, a couple things. Number one, that they no longer believe that the SEC is operating in faithful allegiance to the law, as was cited by Judge Netburn in the SEC v. Ripple case. So why would they continue to give the SEC the benefit of the doubt, thinking, oh, maybe they really do have information we don't have, when they've demonstrated a lack of good faith? And they could, in theory, argue that. And number two, they could point out that in the other instances where the SEC named other coins as securities, they did not sue the creators of those coins. They did with Ripple. Well, that's the assertion anyway. Obviously, I know that Ripple didn't create XRP, but that's what they're asserting, right? That Ripple, it's all the same thing. So instead, they sued exchanges. They went after the exchanges who allowed the trading of these assets. And look, I'm not convinced either of those arguments would necessarily help Coinbase. But see, that just further illustrates the point. They're in a very tough spot right now, because they haven't been sufficiently inconsistent. It's not that they can't try and come up with clever things. I just did off the top of my head a couple things right there, because I was thinking about it before recording this video. I'm like, well, I guess they could do something like that. And I'm not a lawyer, so I don't know to what degree that would or wouldn't be effective. But like, I'm sitting here as a regular person doing my best to try and defend Coinbase, like just trying to, not out of a desire to, but just thinking as an intellectual exercise, what's the best I can come up with? And I don't find it that compelling. That's the best I could. I mean, it's just like, maybe they'll have something, because they get the rock star attorneys. Maybe they'll come with something way better than Moon Family Sedan. You're fine. But they're in a tough spot. So Attorney Morgan continues, though. He shared this. There's a little clip. This is from Coinbase, I believe, right? Yeah. It says, even if each asset issuer were engaged in ongoing marketing efforts at the time of each transaction on Coinbase, and even if those ongoing marketing efforts were somehow viewed as sufficient to establish an implicit investment contract, e.g. as a scheme, it does not follow that secondary market transactions implicate that investment contract. To the contrary, the secondary market transactions on Coinbase fail all four of the Howey prongs. Okay, so what Bill Morgan does, this is what I'm about to share with you, is he takes that statement, that argument from Coinbase, which is a sound argument, by the way. That it's a very good argument. It's accurate. And Ripple's been arguing the same thing, effectively, but not about Coinbase, but in terms of secondary market transactions, so on and so forth. You guys know that. So what Attorney Morgan does, though, is he takes that, what I just read, which is on your screen right here, this little snippet from Coinbase, and then what he does is he keeps the argument intact and uses as many of the exact same words as possible, but then he plugs in Ripple and or XRP in the places where it makes sense. And then once you plug that in, it makes it more clear how ridiculous and how big of a mistake it was that Coinbase, from a legal perspective, delisted XRP. And so here is what Attorney Bill Morgan wrote. He said, seriously, if Coinbase is going to run this argument in a defense to a claim by the SEC and mean it, then its decision to delist and ongoing decision to not relist XRP is an entirely inconsistent and inconvenient fact. Let me just rephrase the submission to reinforce the point by reference to Ripple and XRP. And this is where he's plugging in Ripple and XRP in what I just shared with you. He says, even if Ripple was engaged in ongoing marketing efforts at the time of each XRP transaction on Coinbase, and even if those ongoing marketing efforts were sufficient to establish an implicit investment contract, it does not follow that secondary market XRP transactions implicate the investment contract. To the contrary, the secondary market XRP transactions on Coinbase fail all four of the Howey prongs. So there you go, Paul Grewal and Brian Armstrong. Either your submission above is complete BS, I think it's correct, or your decision to ignore the reasoning of your own Wells submission in relation to XRP is totally arbitrary and unexplained. You reckon the SEC won't notice? Bottom line, Brian and Paul, either no XRP traded on Coinbase is not a security, or they know other cryptos on Coinbase are securities. Can't have it both ways, boys, when you make such a submission in your Wells notice response. Now, he's spot on with that, and this is a truly tough spot. And there's another consideration, by the way, because again, I do think that Coinbase was acquiescing, but don't forget this was also at a time where Coinbase was trying to go public. They were IPO like priority number one, right? Because again, Ripple got sued December 2020, and Coinbase ultimately did have their initial public offering in April of 2021, just months later. So wouldn't it have gummed up the works if they didn't delist XRP? Might that have been a factor as well, and it's now biting them on the rear side? It's possible. I mean, to have been a fly on the wall in the rooms at Coinbase HQ when they were discussing such things, that would be interesting. We'll never know, but perhaps that would have been a consideration here. Either way, XRP was just unfortunately thrown under the bus. And again, I still retain a certain amount of sympathy, just as I had over 2 years ago, but it doesn't change the fact that, from a legal perspective, given their actions since then, and not been consistent, they're not consistent. And the only other thing you could really argue, again, is what I said just several minutes ago, which is that it is true that the SEC sued Ripple, but with these other coins that the SEC is alleging are securities, they're just making that claim, but then not going after anybody that's in that ecosystem other than the exchanges. So that's a market difference right there. Either way, you don't treated us wrong, Coinbase. No, I get it. But it'll be interesting to see how they try and crawl their way out of this. I don't know what the hell they're going to argue. But as soon as we see it, because at some point, presumably, it may come up, we'll be talking about it. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.